for Mount Waverley.
Thank you, Acting Speaker. And I rise to speak on the Justice Legislation Amendment Serious Offenders and Other Matters Bill 2019. And I thank the previous members for their contributions. And I note the member for Broadmeadows and Bendigo West for their important comments, which we'll refer to later. I'd also like to thank the Minister for Corrections as well as the Attorney-General for their work on this bill. And it is important that we are continually working on ways to keep our community safer. This has always been and will always be a clear objective of the Andrews Labor government. One crime is too many, but our society unfortunately has the existence of crime, and no matter how hard we try, we're unlikely to get rid of it all forever. So our justice system is incredibly important to keep our community safe. The main purpose of this bill is to update the operation of the prison system's parole and post-sentence scheme. And this bill takes into account the work of former High Court Justice Ian Callanan's AC's review from 2013 into the Adult Parole Board's operations. The bill amends 3 existing acts: the Corrections Act 86, the Serious Offenders Act of 2018, the Children, Youth and Families Act of 2005. And the main points of this act would be to improve the administration of the prison system, in particular by excluding for all prisoners in all prisons the application of emergency managing days in regard to the riot at the Metropolitan Remand Centre in 2015 and all future cases of emergencies, riot and other significant security incidents. It also improves protections of victims of crime from prisoner correspondence that may be distressing or traumatic or place them at risk of exploitation or manipulation, and enables victims of crimes to access monies from the Prisoner Compensation Quarantine Fund where the prisoner was on remand at the time instead of at the moment, whereas they have to be actually sentenced. Also allows prisoners to request delayed release, which, although would happen rarely, is important, I believe, for the community safety going forward. We're also improving administration of our parole system by modernising the membership, and I'll come back to that a bit later. Improving operation of the post-sentence detention and supervision scheme, and enabling publication of research, because the sharing of research will allow us to improve a system based on evidence and evaluation. So in regard to the emergency management days, we're assuring the prisoners involved in any future emergencies, riots and other significant security incidents are excluded from application of emergency management days, and this amendment will specifically apply to the prisoners who were involved in the events which took place at the Metropolitan Remand Centre in 30 June 2015 and 1st of July 2015, and the security response to that event. This will include, for example, a fire caused or contributed by any prisoner, or attack of any prisoner on another prisoner, etc. And this reflects the basic principle which we have in this House, and I think we'd all agree with, is that a prisoner should not receive a reduced sentence when they cause or contribute to a significant breach of custodial security. Now, it's not often that we make retrospective laws, and that's for a good reason, but I think it is appropriate in this case because this reform reflects the paramount principle that a prisoner should not receive a reduced sentence when they have caused the problems. The bill is not criminalising behaviour that was previously lawful, so therefore is not retrospecting in that regard, but is clarifying the scope of the Secretary's discretion to reduce the length of a sentence of imprisonment. It's also worthy of note that there are no court cases relating to these emergency management days currently, and there was a court challenge by a prisoner to a denied application for emergency management days that was rejected by the Supreme Court in May of 2018. So, as it stands, if we look to the Adult Parole Board changes, members of the Parole Board are limited to judges or retired judges, and this is proving to be limited of a scope to choose from, and the appointments to the board are more problematic than they could be. So this bill will amend the Act to allow lawyers of at least 10 years' experience to be appointed as a chairperson or deputy chairperson to the Adult Parole Board. 10 years has been found to be an appropriate length of time and can be seen by other jurisdictions to be indicative of what is a fair and reasonable minimum standard. But it's fair to say that this minimum standard does not necessarily affect the selection criteria that would be applied, as that would then be applied to the pool that adhere to that minimum standard. So currently, to be appointed as a judge of the Supreme Court, for instance, you must be a lawyer of 5 years standing. So I think it's fair to think that we could have a chairperson of the Parole Board who is twice as experienced in the field than a potential Supreme Court judge. This reform is also consistent with who can be appointed as the chairperson of the post-sentence, or deputy chairperson for that matter, of the post-sentence authority under the Serious Offenders Act. And it's important to note, however, that the number of years' experience, as I said, is a minimum requirement. The selection criteria will also include consideration of the applicant's areas of specialisation, whether the applicant has significant experience in practising criminal law and in-depth knowledge of criminal justice system more broadly. If we compare that to other states, we'll be suitably in line. South Australia and Tasmania, the chairperson they allow one who's not required to be a judge or lawyer. In Queensland, the president must either be a retired judge or lawyer who has engaged in legal practice for 5 years. In the ACT, they must have 5 years' experience. And I note the member for Broadmeadows pointing out that our parole system is now the toughest parole system in the country, and that this is a testament to improving community safety. And I also note that victims' considerations are certainly already reflected in our parole system. In regard to the Prisoner Compensation Quarantine Fund changes, currently this fund only applies for compensation paid for injuries suffered by sentenced prisoners, but I think it's fair and reasonable to extend that to prisoners who are on remand at the time, who are then later sentenced. The bill will extend the operations fund to unconvicted prisoners and then subsequently convicted, as I said. So our victims register utilises an opt-in model like all other states and territories in Australia. The model ensures that victims are given autonomy over the situation to choose whether they updated on the offender or not. Being contacted about an offender may be distressing or traumatic, and that is why other aspects of change in this bill certainly take that into account. In cases where a prisoner is awarded $10,000, the money is then quarantined for 12 months, and this allows victims to make claims for that money. My own district of Mount Waverley has the honour to be home of the Victorian Police Academy, and our academy is very full as we recruit and deploy an extra 3,135 officers in frontline police. I'd like to take the time I have left to give a shout out to our whole police force, the men and women who serve us on a daily basis, dedicated officers, administration. We thank you all for your service. And as my good friend and colleague, the member of Bayswater, will stand up no doubt soon, we all know that our police have a very wide range of experience and show us on a daily basis the esteem and respect that they deserve. So no matter how much we support our police, we also rely on our strong justice and corrections system, which also includes our dedicated corrections officers. So this bill is once again strengthening our justice system to better protect our Victorians, and it shows the commitment of our Andrews Labor government to protect our community. I commend the bill to the House.